This will be a 180 jury charge. Ready? Begin. Ladies and gentlemen, you have heard the argument of counsel, and it is now up to me, as the judge, to instruct you on the law that you as jurors must follow in reaching a verdict in this case. The credibility of any witness may be attacked by introducing evidence that on some previous occasion he made a statement inconsistent with his testimony in this case on a matter material to the issues. Evidence of this kind may be considered by you in connection with all the other facts and circumstances in evidence in deciding the weight to be given to the testimony of that witness. You are the sole judges of the credibility of the witnesses and of the weight to be given to the testimony of each of them. In determining the credit to be given, any witness you may take into account his ability and opportunity to observe, his memory, his manner while testifying, his interest, bias, or prejudice he may have, and the reasonableness of his testimony considered in the light of all the evidence in the case. A fact may be proved by circumstantial evidence. Circumstantial evidence consists of proof of facts or circumstances which give rise to a reasonable inference of the truth of the fact sought to be proved. In deciding whether any fact has been proved, it is proper to consider the number of witnesses testifying on one side or the other as to that fact, but the number of witnesses alone is not conclusive if the testimony of the lesser number is more convincing. In considering the evidence in this case, you are not required to set aside your own observation and experience in the affairs of life, but you have a right to consider all the evidence in the light of your own observation and experience in the affairs of life. In determining whether any proposition has been proved, you should consider all of the evidence bearing on the question without regard to which party produced it. When I say that a party has the burden of proof on any proposition, or use the expression, if you find or if you decide, I mean you must be persuaded, considering all the evidence in the case, that the proposition on which she has the burden of proof is more probably true than not true. The plaintiff claims she was injured and sustained damage while the defendant failed to exercise ordinary care. The plaintiff further claims that the incident described in the information was a proximate cause of her injuries. The defendant denies that she failed to exercise ordinary care in doing any of the things claimed by the plaintiff, denies that any claimed act or omission on the part of the defendant was the proximate cause of the claimed injuries, and further denies that the plaintiff was injured or sustained damages to the extent claimed. You must not consider the question of whether there was contributory negligence on the part of plaintiff, because under the law, a child of the age of the plaintiff is incapable of contributory negligence. If you decide for the plaintiff on the question of liability, you must then fix the amount of money which will reasonably and fairly compensate her for any of the following elements of damage proved by the evidence to have resulted from the wrongful conduct of the defendant. 1. The nature, extent, and duration of the injuries. 2. The disability resulting from the injuries. And 3. The pain and suffering experienced as a result of the injuries. If the greater weight of the evidence does support the claim of the plaintiffs, then your verdict should be for the plaintiffs and against the defendants. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence of the case. You heard a lot about negligence, and I charge you that negligence is the failure to use reasonable care. Reasonable care is that degree of care which a reasonably careful person would use under like circumstances. Negligence may consist either in doing something that a reasonably careful person would not do under like circumstances, or in failing to do something that a reasonably careful person would do under these circumstances. I charge you that negligence is a legal cause of injury or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such injury or damage so that it can be reasonably be said that but for the negligence, the injury or damage would not have occurred. In order to be regarded as a legal cause of injury or damage, negligence may not be the only cause. Negligence may be a legal cause of injury or damage, even though it operates in conjunction with the act of another or some other cause if such other cause occurs at the same time as the negligence, and if the negligence contributes substantially to producing such loss, injury, or damage. Now, if you find for the defendant, you will not consider the matter of damages, but if the evidence proves negligence, which was a legal cause of injury or damage to the plaintiffs, and for which the defendants or any of them are responsible, you should award an amount of money that the greater weight of the evidence shows will fairly and adequately compensate the plaintiffs for such injury or damage, including any such damage as the plaintiffs are reasonably certain to incur or experience in the future. Now, with reference to the claim of the plaintiff, you may consider the following evidence: any bodily injuries sustained by her and any resulting pain and suffering, disability, disfigurement, and loss of capacity for the enjoyment of life experienced in the past or to be experienced in the future. There is no exact standard for fixing the compensation to be awarded on account of such elements of damage. Any such award should be fair and just in the light of the evidence. You may also consider the reasonable value or expense of hospitalization, medical and nursing care, and treatment necessarily or reasonably obtained by the plaintiff in the past or to be so obtained in the future. You may consider any earnings and working time lost in the past, any loss of ability to earn money in the future. Now, as to the claim of Mrs. Peters, the mother, you may consider any loss by reason of her husband's injury, of his services and attentions in the past and in the future. Now, if the greater weight of the evidence shows that the plaintiffs have been permanently injured, you may consider her life experience. The mortality tables received in evidence may be considered in determining how long she may be expected to live. Such tables are not binding on you, but may be considered together with other evidence in the case bearing on her health, age, and physical condition before and after the injury in determining the probable length of her life.